Because housing is a human right, refugees and other newcomers to the United States deserve to live in a community of their choice, free from discrimination. Safe, stable, and affordable housing is not a luxury, but a necessity. Unfortunately, some newcomers cannot secure such housing due to discriminatory practices. Hello, I'm Lynette Pearl, the Senior Housing Officer with Refugee Housing Solutions, and welcome to our Housing 101 Fair Housing webinar. Before getting into the webinar, I want to summarize who we are and what services we provide. RHS is a technical assistance and capacity building support project for resettlement practitioners, housing providers, and community groups, including refugees and other newcomers to the United States. The RHS team partners with these stakeholders and others, including government and private sector partners, to develop and implement innovative initiatives to increase the availability and affordability of housing for refugees and other newcomers. We offer various trainings and education materials such as documents, toolkits, and fact sheets. We also provide on-demand technical assistance and support to resettlement practitioners, newcomers, landlords, housing providers, sponsors, volunteers, and any stakeholder who wants to participate in the resettlement space. To schedule an appointment with one of our team members, you can go to our website and under our Technical Assistant tab, enter your contact information and details of your TA request into our booking schedule system. And here's just a snapshot of some of the toolkits we provide on our website. And after this webinar, our contact information will be provided. So let's get started. The learning objectives for this webinar, I will give an overview of the Fair Housing Act, and I will talk about why the Act is so important for refugees and other newcomers. I'm going to also cover what classes are federally protected and what rights your client has during each rental life cycle. And we're going to talk about how to support a newcomer applicant and tenant in filing a complaint. Now, I do want to have a disclaimer before proceeding with this webinar. I want to be clear that this training is for informational purposes only and should not be relied upon as legal advice. So if you have any legal questions or concerns, please consult your legal department or your local fair housing agency. So I'm going to give a brief history of the Fair Housing Act so you can better understand where it originated from. So on April 11th, President Lyndon Johnson signed the Civil Rights Act of 1968, which followed the Civil Rights Act of 1964. Now, the 1968 Act expanded on previous acts and prohibited discrimination concerning the sale, rental, and financing of housing based on race, religion, national origin, sex, handicap, and family status. Now, Title VIII of the Act is also known as the Fair Housing Act of 1968. The enactment of the Fair Housing Act on April 11, 1968 came only after a long and challenging journey. From 1966 to 1967, Congress regularly considered the Fair Housing Bill, but it needed to garner a strong enough majority for its passage. Unfortunately, when the Reverend Dr. Martin Luther King Jr. was assassinated on April 4th, 1968, President Lyndon Johnson utilized this national tragedy to urge for the bill's speedy congressional approval. Since the 1966 opening housing marches in Chicago, Dr. King's name has been closely associated with the fair housing legislation. So as I stated, the Fair Housing Act is a federal law prohibiting discriminatory housing practices based on a person's color, race, religion, sex, national origin, disability, and familial status. Now, the Act's foundation is the right to choose. Again, the Act's foundation is the right to choose housing free from unlawful discrimination. So why is this so important? Well, the FHA ensures that a protected class member is not discriminated against during a housing transaction. Many newcomers have experienced discrimination, and you, as a staff member, sponsor, and volunteer, play a crucial role as an advocate. You understanding their rights is key to helping them secure the housing of their choice. So, who's protected by the fair housing laws? Well, fair housing laws protect all, I repeat, all individuals seeking housing, including renters, homebuyers, person obtaining a mortgage or homeowners insurance, and others. One's immigration status does not affect his or her fair housing rights or responsibilities. Now, in this webinar, I will cover federal protections. However, it's very important that you know your state and local laws as well. All states must comply with federal housing laws, but some state and local laws are more expansive and provide additional protections. For example, in Illinois, one's source of income makes it unlawful to be discriminated against. So, if this is available in your state, this additional protection will benefit a newcomer client receiving financial assistance. So, here is just a snapshot of the state of Illinois. As you can see, of course, the Federal Fair Housing Act protections, but you can see there are additional. You see the Illinois Human Rights Act, the Cook County, and the Chicago Fair Housing Ordinance. So let's talk about the protected classes. And the first one we're going to talk about is people with disabilities. The Fair Housing Act prohibits housing providers from discriminating against people because of their disabilities or treating them less favorable than others because of their disabilities. Now, the Fair Housing Act defines individuals with disabilities as those with mental and or physical impairment that substantially limited one or more major life activities. Now, major life activities include caring for oneself and performing manual tasks. Now, throughout this presentation, I will be giving examples of what discriminatory practices look like. So, for this protected class, an example would be if a housing provider refuses a credible, reasonable accommodation request or modification. And I'm going to talk a little bit about what those are. They have a blanket no pet policy, including for service animals, or charges a pet deposit on a service or emotional support animal, or shows a disabled applicant only ground floor apartments. Now, I want to add a caveat to that. That's if the applicant only requested to be shown only ground floor apartments. But if they do not request that, and that's all they do, then that would be a form of discriminatory practice. So we're going to talk about reasonable accommodation and modification. A reasonable accommodation, it is a change, exception, or adjustment to a rule, policy, practice, or service. Now, a reasonable modification is a structural change made to the premises. Now, the purpose of a reasonable accommodation or modification is to provide equal access to housing for people with disabilities. Now, reasonable accommodations and modifications can make otherwise inaccessible units accessible for those with disabilities. Accommodations and modifications organically increase their housing opportunities in areas with transportation and amenities. So, who can request a reasonable accommodation and modification? Well, an applicant and or tenant with a physical or mental impairment that substantially limits their major life activities. Now, a request for a reasonable accommodation or modification may occur at any time during the application process. This includes the signing of a lease or tenancy, or even during the eviction or non-renewal process. Moreover, the request can be made by a family member or person acting on behalf of the person with the disability. So you, as a representative for your client, can make a reasonable accommodation and modification in their behalf. One of the questions is who pays for the reasonable accommodation modification when it is needed? Now, the housing provider pays for the modification unless the request puts an undue financial and administrative burden on the housing provider. HUD does have rules and regulations determining the guidelines for what is considered a financial and administrative burden. So let's talk about what are some examples of accommodations and modification. So reasonable accommodation would be assigning an accessible parking space for a tenant with mobility challenges, or allowing a tenant to move to a ground floor unit to accommodate mobility limits without any financial charges, like a transfer of unit charge. One of the biggest things is adjust rent payments to align with assistance income payment dates. So, for example, if you have a client, they receive assistance, their assistance come in on the 5th. However, rent is due on the 1st. You can put in a reasonable accommodation that they pay their rent on the 5th without any late fees. So that's going to accommodate when they get paid. Another big thing is to allow a live-in aid. If you have a client with a disability, in order for them to be independent, they would need a live-in aid to live with them. You can request a reasonable accommodation to allow a live-in aid. Now, this is very important, especially if you have a client that's living in an income-based unit, because again, rent is based on income. If they get a live-in aid and the reasonable accommodation is approved, then the live-in aid can live there without their income being considered as part of the rent. And to permit a service animal and a no pets building for a tenant who needs it for physical and emotional support without any financial charges. I do want to add a caveat to that too. Um, when you have a service animal or a pet and a reasonable accommodation has been approved, um, the housing provider cannot charge a pet fee or a pet rent. However, if the pet does damage the unit, that those damages do come out of the deposit. So with reasonable modification, it would be add, like, for example, grab bars to a bathroom or allowing a tenant with impaired manual dexterity to replace locks or door handles with adaptions. Installing visual doorbells or fire alarms, lowering kitchen cabinets. Again, with the lowering the kitchen cabinets, as long as it's not a financial burden on the housing provider, and also installing a ramp to the front door of the building and widening doorways in a unit for wheelchair access. So again, these are just some examples. So how do you do a reasonable accommodation request or modification? Well, it can be done verbally or in writing. Some housing providers may have a form that you would have to fill out for it. I do recommend making it in writing, the request in writing for documentation and tracking purposes. Housing providers must only set policies or formal procedures that cover their reasonable accommodation or modification. Um, so if you're dealing with a housing provider that's receiving government funding, or the unit is receiving a government subsidy, they are required to have this request, a process of how they respond to reasonable accommodation modification requests. They have to respond in a timely manner. If the request to be considered reasonable, it must be technically possible. It must not change the basic nature of the housing program being used, and it must not cause an excessive financial or administrative burden to the housing provider or cause harm or damage to others. Now, they can be denied. The reasons for denial, if the request is not on behalf of the individual, there is no disability related need for the accommodation or modification. And as I mentioned, if the modification imposes an undue financial or administrative burden on the housing provider, and that's just FYI. And you can file a complaint if a reasonable accommodation or modification is denied. And all this information will be provided for you of how to go about filing a complaint. And this is just an overview of you either can contact your local fair housing agency, or you can call or file a complaint on HUD's website, or mail or complete a complaint form or letter to the Office of Fair Housing and Equal Opportunity. So the next protected category is race and color. When Congress had passed the Fair Housing Act in 1968, this was one of the primary goals, was to prohibit racial discrimination in the sales and rentals of housing. Nonetheless, more than 50 years later, race discrimination in housing continues to be a problem throughout the United States, unfortunately. It is illegal for housing providers to treat someone differently because of their actual race, color, or perceived race or color. A housing provider cannot discriminate against a tenant or applicant because of their association with another race. For example, a white tenant cannot be treated differently because they have African American guests or vice versa. Some other examples of refusing to rent to someone only because of skin color or race. Steering is a big one. Steering is when a housing provider steers an applicant to a specific building with renters of similar racial background, and steering can be with any class. So if you have, for example, we're going to talk about family protection. If you have an actual landlord tries to steer an applicant to a building where all children, or try to set an all a child-free setting, or they try to get an applicant to apply to a building where children at, they want children in a specific building. So that's considered steering, and that's illegal. Refusing to rent to a person with darker versus lighter skin color of the same ethnicity. I'm going to use me as an example. I am an African American woman. I have siblings. There's three of us. My middle sibling is a lighter skin African American. I'm considered medium skin. Discrimination could happen if you have a landlord that wants to rent to her because she's a lighter skinned African American versus me getting denied because I'm darker skinned. So that can happen within a same ethnicity group discrimination. Another example, state that only rent to people who speak English. So we're going to talk about national origin. The Fair Housing Act prohibits discrimination based on national origin. It is illegal for a housing provider to discriminate against an applicant or tenant because of the country or nation they or their parents or ancestors come from, or because they have a name or accent associated with a national origin group, or if they participate in certain customs associated with a national origin group. Now, one of the most frequently asked questions, which would be under this protected class, is the requested immigration status. Can a landlord request immigration documents? And the answer is yes. A landlord can request immigration documentation and conduct inquiries as long it is used to determine if an applicant meets the rental criteria. Now, the same request and procedure would have to apply to all applicants in order for that landlord to be in compliance. Any procedure to screen for potential applicants and existing tenants for citizenship and immigration status may violate the Fair Housing Act. And is the protections under the National Origin Housing Discrimination. So if you are in doubt about a certain situation that your client has gone through, contact your local fair housing agency or HUD to get better insight. So let's talk about some examples under this. Would be if a landlord would ask a Hispanic applicant how many children they have, but do not ask all applicants the same question, or refuses to rent to a newcomer based on ethnicity, rents only to certain ethnicities. This can go both ways. I have heard some landlords say, well, I only rent to refugees and newcomers. That goes against the fair housing laws. So it could go either way. If they tell tenants they must speak English when outside of their apartment. So we're going to talk about religion next. The Fair Housing Act prohibits housing providers from treating applicants and tenants differently because of their religion, their wearing of religious clothing, or other engagement in religious practices and rituals. So some examples would be refusing to rent to a newcomer, or, as I talked about, steering a rental applicant to another property based on stated or perceived religion, discourages or prohibits religious art or decor inside a rental unit, or prohibits community room use for religious related purposes for only some religions, while allowing other tenants to use it for secular gatherings such as parties. And this is a big one, is family status. Now, the Fair Housing Act, with some exceptions, prohibit discrimination in housing against families with children under 18. In addition to prohibiting an outright denial of housing to families with children, The Act also prevents housing providers from imposing special requirements or conditions on tenants with children. Under FHA, the marital status of adult tenants is irrelevant. It does not matter if the adult members of the family are married, divorced, single, widowed, or separate. So, for example, a single father with children has the same protections as a married couple with children. FHA also protects families with children, even if the children aren't living with their biological parents. A landlord cannot place an unreasonable restriction on total number of persons residing in the dwelling. However, I do want to add this caveat. Landlords are required to meet the occupancy and code requirements. So if you have any questions about that, I highly recommend you contact your local housing authority. They are very knowledgeable about what occupancy and code requirements are, or your code department. So there are some reasons why a landlord can refuse larger families is because it goes against the occupancy and code requirements for that particular home or building. So here are some other discriminatory examples is refusing to rent to a family with children. Now, I want to add another caveat to that. That is if it's a senior living, specifically for senior living, then the landlord can not accept an application because it's specific senior living. Or if they designate a building or floor or unit as child-free, as I spoke about earlier, charges a higher rent or security deposit because a family has children. Now, there's a difference if they're charging a higher security deposit because of the applicant does not have a credit history versus because they have children. And make negative comments about individual or families based on their family size or status. So we're going to talk about sex, gender identity, and then we're going to also talk about sexual harassment. The Fair Housing Act makes it unlawful to discriminate in housing based on sex. Now, in 2020, the U.S. Supreme Court decision, Bostock versus Clayton County, expanded the Civil Rights Act of 1964 to include sexual orientation and gender identity as protected classes. So some examples would be not renting to an individual because of stated or perceived sexual orientation or because of their gender, or not taking action to protect domestic violence victims. This would fall under this protected class. Violence Against Women's Act, VAWU is called VAWU. That federal protection not only protects women, but also protects men of domestic violence. And one of the things would be discriminatory if you have a client that is a victim of domestic violence, it could be a he or she, and they want to break their lease or transfer to a different apartment, and the landlord does not allow them to do that, that goes against this particular protection. If they want to break their lease and the landlord wants to charge them an early termination fee, that they are protected under VAWU to break their lease because they are a victim of domestic violence without any financial hardship. So, and we're going to talk about sexual harassment. In recent years, HUD has focused on extinguishing sexual harassment in the housing space, especially for low-income households with limited options. Notably, women with limited resources often have little recourse but to tolerate sexual harassment to obtain or secure housing for themselves and their children. And it does now include men. It does include men as well. I want to add that in there. But because of possible cultural differences and the high risk of victimization of newcomers, it is essential that they know their rights, your client know their rights, and what behaviors are unacceptable from landlords, housing staff, and fellow tenants. Your client has a right to search for and secure housing free from discrimination and sexual harassment. Sexual harassment violates the Fair Housing Act, and under the Fair Housing Act, an individual can claim sexual harassment if they demonstrate that the act was unwanted, regardless of how they submitted to the sexual act. Now, with sexual harassment, I want to say this again, the gender of the victim and harasser, it does not matter. However, women are most often the victims, but not in every situation. Men can be victims of sexual harassment. So regardless of the gender of the victim or the harasser, FHA protects all from sexual harassment. So one of the examples we have seen, especially in the housing space, is when a housing provider offer to reduce rent in return for sexual favors, or they make unwelcome sexual advances and off-color sexual comments. One of the things, especially working this field, I have found with newcomers, if a newcomer applicant does not submit to a sexual advance, threatening to call ISIS, or this can also be for a client not submitting to a sexual advance, threatening to evict them or to call ISIS. If they fall behind on their rent, offering a reduction or the rent or the debt if they give into a sexual favor. And again, this goes against um, the fair housing laws, and they're protected under sexual harassment. So we did cover the Fair Housing Act and the protected classes. Now I want to go over what rights your client have during the home rental process. So during the application process, a newcomer is about to enter into a legal binding document when they sign a lease. So with that being said, they have the right to understand what that lease is because it's legally binding. They have a right to a translation accommodation. If you're dealing with a housing provider that is receiving government funding or government subsidy, they are required to provide translation services for their non-English speakers. They have a right to know what their applicant have their right to have the application evaluate fairly. They have a right to inspect the unit if it's available. Again, best practices: do not have a client sign a lease until they actually inspect the unit. They have the right to be told what the state required disclosures are. I'll talk a little bit about what some of them are. They have a right to know how to pay, when to pay, and when to get their deposit back. Now, each state is specifically different when it comes to the return of deposits, and they have a right to be told the reason for a denial notification if their application has been denied. One of the biggest things we discuss as a best practice is having staff or the client inspect the unit before signing the lease. One of the rights the client has is the right to have a copy of the move-in checklist in order to document and dispute any pre-move-in damage. They also have a right to be present during a move-out inspection as well. And I'll talk about what their rights are later in the webinar when it comes to move-out inspections. Now, as I mentioned, there are federal, state, and sometimes local disclosures that applicants have the right to know before signing a lease. Because disclosures vary by state, it's essential for you as a staff member to understand which ones are relevant to your client's situation. However, there are federal disclosures such as Megan's Law and the lead paint disclosure. Now, under Megan's Law, landlords must disclose the presence of registered sex offenders in the area. Although the disclosure is a federal requirement, each state has different notification requirements as well. Now, what the lead disclosure rules are pertain to most private and publicly owned rental properties and to all federal assisted housing. There are some exceptions, as not all states require the same disclosures, but all states must comply with the federal lead paint disclosure requirements regarding buildings built before 1978. Again, your client has a right to inspect the unit before signing the lease. They have a right to understand the lease in detail before signing it. We talked about translation accommodation, and this is so important. They need to know the term of the lease they're signing, especially in the resettlement process, because you might have a client, they are going to possibly live in this unit, say, for example, 3 months, but their goal is to resettle in a different state or a different city. So they need to know, okay, if I terminate this lease, if there's an early lease termination, what will be the penalty for me terminate the lease? So that's why they need to know the lease terms. How much is the security deposit? Again, there's security deposit interest. Some states require that if they have a security deposit, that the landlord put it in an escrow account and interest be earned. And if they are entitled to their security deposit back, they get that with interest. Any late fees or delayed rent payment, what are the consequences for that? They have a right to know that. They have a right to know what are the rules regarding pets, visitor, noise, and hallways. And it's very important they know that because it's in the lease. Because if there's a lease violation and they continue to violate the lease, guess what? They're going to get evicted. The eviction process will start. They have a right to know what their new renewal options are, and again, early termination and what the penalties would be for terminating a lease early. They have a right to live in a safe sanitary housing, and when they submit maintenance orders, to have those maintenance orders done in a timely manner and be protected from retaliatory actions when they do exercise their right as a tenant and not be threatened with undue eviction. And we'll talk about the eviction process as well. And have a right to possess and control the property based what's outlined in the lease. One thing that a lot of tenants are unaware of, again, is their rights when it comes to tenant termination. If the unit is considered uninhabitable conditions, they have a right to terminate their lease without any financial hardships. Again, if they are a victim of domestic violence, they have a right to terminate their lease, or they have a right to transfer to a different unit or transfer to a sister property if it's available. They're required to have notice and permission for a landlord or property manager to enter their rental unit. They have a right to privacy. Now, this varies from state to state when actual landlord has to give notice when they're going to enter a unit. Now, I want to add a caveat. If there's an emergency, then the landlord does not have to give advance notice. But if they're doing a regular routine maintenance repair, then they would have to give them a notice that they're going to enter the unit, advance notice. And again, that depends on the state. And here's some other notices that they have a right to know: when a rent increase, when the lease renewal, lease termination, and if their ownership is going to change. They have a right to know that in a timely manner. So now we're going to talk about the unpleasant business of eviction. And this is where a lot of people don't understand where their rights are. Eviction, it is a legal action by which a housing provider ends a tenant's lease and asks them to vacate the rental property at a time decided by local laws and statutes. So let's talk about what are some evictable offenses. Of course, the biggest one is non-payment of rent, incomplete rent payments, which eventually equates to non-payment of rent. If there are some lease term violations, that's why it's important that they know what is considered a lease violation, because if there's so many lease violations, a landlord has the legal right to start the eviction process. Housing unauthorized tenants, again, they need to know what the rules and regulations that should be outlined in their lease, because if they have an unauthorized tenant or a person living in a unit beyond the time that the lease states, a landlord has a right to start the eviction process. Evidence of criminal activity in the rental unit, and the domestic violence perpetrator. So these are some evictable offenses. So during eviction, a tenant does have rights. They have a right to due process. They have a right to legal assistance and representation, and the landlord must comply with the state's formal eviction process. Now, this is a general flow chart of how the eviction process works. A tenant must be given a notice to vacate first. This is how the ball gets rolling. I get a lot of calls. I get a lot of frantic calls from housing specialists. My client is being evicted right now. And I'm like, well, are they being evicted or did they get a notice to vacate? Because that's the biggest difference. Well, they're getting a notice to vacate. Okay. This is getting the eviction process started, but it's not an actual eviction. So the notice to vacate usually is 5 to 3 days, depending again on what your lease says in your state. Will give this tenant grace period to remedy what is going on. So, for example, if they're behind on rent and they get a notice to vacate, it gives them opportunity to work with the landlord to pay the rent or come up with a payment plan or just pay the rent, the debt, the delinquency. So once that happens, say if the notice of vacate happens and it's not remedied, the tenant does not have to leave quite yet. The landlord then has to go through a process and file a complaint. So the landlord does have to file a complaint legally, and then that's when the tenant is summoned to an eviction court. Now, once the eviction summons has happened, a tenant does have a right to have legal representation. Legal representation. So if you have a client, say that they got a notice to vacate, you should be looking for resources to help them, especially if they're behind on rent, finding them some rental assistance, but also working with the landlord to see if it can be remedied. If not, if they get that summons, evictions summons, finding legal aid, contacting legal aid, because sometimes there are unfortunately long waiting lists to get them some free legal representation. So if they do have to go to eviction court, they have someone there to support them. Now, if they go to court, two things can happen. If the landlord wins, the tenant is given a specific time to move out. Now, if they do not vacate by that deadline that's given by the court, then the landlord has every right to have law enforcement come in and physically force them out of the unit, remove their things. Now, if the tenant wins, then the judge outlines the conditions by which the tenant can stay in the apartment. Now, I want to talk about it's called retaliatory eviction. It is illegal, and not all states recognize retaliatory eviction as a defense. So, again, check with your state laws. And this is when a landlord may not evict a tenant for exercising a writ which is protected under the lease and law. And some examples of retaliatory practices is a newcomer tenant files a complaint to the health department regarding a mold issue in their home. And due to this complaint, the landlord refuses to renew their lease after the term of the lease. Or if a tenant organized or participate in a tenant organization, the landlord harasses and or threatens to file a court eviction due to their participation. And I want to again stress how important it is for them to know their rights when it comes to sexual harassment. It would fall under this. So if you have a client, they're stating that a landlord made a sexual advance, they decline, and then the landlord decides to start eviction proceedings and they're not behind on their writ. They have no lease violations. They've been a good tenant, but they started eviction proceedings. This will file under retaliatory, or if they threaten to call ISIS on them. And here's some other illegal activities. They force a tenant to move without an eviction order. They change an apartment or housing door locks without an eviction order. They shut off utilities without an eviction order, or they remove tenant belongings without an eviction order. Now, tenant does have move-in rights. As I stated earlier, a tenant has a right to be part of the move-out inspection. I highly recommend that they attend the move-out inspection because that is when they can dispute any damages that are beyond any damages or wear and tear should not be taken out of deposit, but any damages that they was present before they move in, they can say, well, that was present during the move in. You cannot charge me that during my move out. So that's why it's important they be there for the move in inspection and the move out inspection. And they have a right to a timely security deposit if it's applicable. If they're due a security deposit, again, you would have to check with your state laws because the state laws will tell you the timeline when a landlord would have to return the security deposit. And if your state has interest included, they would have to return the security deposit with the interest as well. And they have a right to personal property storage. Again, this varies by state and local ordinance. Now, if your client's rights have been violated, there is a process I highly recommend for them to be prepared. Advise your clients to keep detailed records. They need to document all meetings if possible and phone calls. Keep detailed records about everything that was said or actions taken. They need to save copies of their application, their signed leases, security deposit, and rent payments. I say they should have that anyway. And if a complaint must be filed, they should collect written witness statements. If a witness was there when the infraction happened, they should have their full name, signature dates, and contact information. And there's several ways that a complaint can be filed. They can either contact the Federal Housing Equal Opportunity Office, and here's the number. And again, this will be available. You can pull down this information after reviewing this webinar, or they can contact HUD directly or a local fair housing agency. And I'll talk about a local fair housing agency after this. And file with HUD within a year after the discrimination occurs, and file in federal court within 2 years after the discrimination has occurred. I highly recommend that you know who your fair housing agency is and work with them. They will be a great resource to you, especially if you have questions about fair housing laws, or if there's a questionable situation, you can run it by your rep, your fair housing representative. They do investigate potential discrimination. They do advocate for a housing provider as well as behalf of a newcomer applicant and tenant. They can help file a Department of Housing and Urban Development complaint. They also help resolve case with a non-compliant or discriminatory housing provider, and they have access to actual litigation experts and attorneys. If the fair housing law has been broken, they have access to that expertise. The reason why I recommend you work with your local fair housing agency is because they know all the, not just the state, but also the local laws as well, versus if you go to a federal entity. Well, this concludes this fair housing webinar. I know I've given you a lot of information. However, you can contact me through my email, which is lpearl@cwsglobal.org. Or if you want, there's two ways you can request a TA. As I mentioned earlier, you can go to our booking system and book a TA, or you can send an email to our TA@refugeehousing.org. So again, thank you for attending this webinar and have a blessed day.